बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलाम अलैका या रसूलुल्लाह वस्सलाम अलैका या हबीबल्लाह। प्यारे व्यूअर्स, उम्मीद करता हूँ आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके और आप इससे फ़ायदा हासिल कर सकें। प्यारे व्यूअर्स, आज हम पढ़ेंगे सेक्शन 346, प्रोसीजर ऑफ मजिस्ट्रेट इन केसेस which he cannot dispose of. Number one, if in the course of an inquiry or trial before magistrate in any district, the evidence appears to him to warrant a presumption that the case is one which should be tried or sent for trial to the court of session or the high court by some other magistrate in such district. He shall stay proceedings and submit the case with a brief report explaining its nature to the session judge or to such other magistrate having jurisdiction as the session judge district. Number 2, the magistrate to whom the case is submitted may, so if so empowered, either try the case himself or send the case for trial to the court of session or the high court. सेक्शन 200 347, section 347, procedure when after commencement of trial magistrate finds case should be tried by court of session or high court. If in any trial before a magistrate before signing judgment, it appears to him at any stage of the proceedings that the case is one which ought to be tried by the court of session or high court, he shall send the case to the court of session of high court or for trial. सेक्शन 200 348, section 348, trial of persons previously convicted of offences against coinage, stamp, law or property. Number 1, whoever having been convicted of penal code with imprisonment for a term of 3 years or upward is with imprisonment for a term of 3 years or upwards shall, if the magistrate before whom the case is pending is satisfied that there are sufficient grounds for the trial of the accused by the court of session of high court, as the case may be sent the accused for trial to such court unless the magistrate is competent to try the case and is or opinion that he can himself pass an adequate sentence if the accused is convicted. Proviso number 2, when any person is sent for trial to the court of session or high court under subsection 1, any other person accused jointly with him in the trial shall be similarly sent to trial. Section 349, section 349, procedure when magistrate cannot pass sentence sufficiently severe. Number 1, whenever a magistrate of the second or third class having jurisdiction is of opinion after hearing the evidence for the prosecution and the accused that the accused is guilty and that he ought to receive a punishment different in kind from or more serve than that to receive a punishment that such magistrate is empowered to conflict to empowered to inflict or that he ought to require to execute a bond under section 106, he may record the opinion and submit his proceedings and forward the accused to a magistrate of the first class, specially empowered in the behalf by the provincial government. 1A. When more accused than one are being tried together and the magistrate considered it necessary to proceed under subsection 1 in regard to any of such accused, he shall forward all the accused who are in his opinion guilty to the magistrate empowered under subsection 1. Number 2. The magistrate to whom the proceedings are submitted may, if he thinks fit, examine the parties and recall and examine any witnesses who has already given evidence in the case and may call for and take any further evidence and shall pass such judgment, sentence or order in the case as he thinks fit and is according to law, provided that he shall not inflict a punishment more severe than he is empowered in inflict under section 32 and 33. Section 350. Conviction on evidence partly recorded by one presiding officer and partly by another. Number one, whenever any sessions judge or magistrate, after having heard and recorded the uh, whole or any part of the evidence in inquiry or a cases trial cases to exercise jurisdiction therein and is succeeded by another session judge or magistrate, so succeeding may act on the evidence so recorded by his procedures predecessor or partly recorded by his predecessor and partly recorded by himself, or he may re-examine the witnesses and recommencing the inquiry or trial, provided that A. Where the conviction was held before a session judge, the High Court, and B. Where the conviction was held before a magistrate, the High Court, or the Court of Session, may, whether there be an appeal or not, set aside any conviction passed on evidence not wholly recorded by the sessions judge or magistrate before whom the conviction was held, such if such court is of opinion that the accused has been materially prejudiced thereby and may order a new inquiry or trial. Number two, nothing in this section applies to cases in which proceedings having been stayed under section 346 or in which proceedings have been submitted to a superior magistrate specially empowered under section 349. Number three, when a case is transferred under the provisions of this code from one magistrate to another, the former shall be deemed to cease to exercise jurisdiction therein and to be succeeded by the latter within the meaning of of subsection 1. Section 350A. Changes in constitution of benches. No order or judgment of a bench of magistrate shall be invalid by reason only of a change having occurred, occurred in the constitution of the bench in any case in which the bench by which such order or judgment is passed is duly constituted under section 15 and 16 and the magistrate constituting the same have been present on the bench throughout the proceedings. Section 351. Detention of offenders attending court. Any person attending a criminal court, although not under arrest or upon a summons, may be detained by such court for the purpose of inquiry into a into a trial of any offence of which court can cognizance and which from the evidence may appear to have been committed and may be proceeded against as though he has been arrested or summoned. Number two, when the detention take place after a trial has been begun, the proceedings in respect of such person shall be commenced afresh and the witness reheard. Section 352, courts to be open. The place in which any criminal court is held for the purposes of inquiring into a trying any offence shall be deemed an open court to which the public generally may have access so far as the same can conveniently contain them, provided that the presiding judge or magistrate may, if he thinks fit, order at any stage of any inquiry into or trial of any particular case that the that be or remain in the room or building used by the court. Section 353, evidence to be taken in presence of accused, except as otherwise expressly provided. All evidence taken under chapter 11 shall be taken in the presence of accused or written or when his personal attendance is dispensed with in presence of his pleader. Section 354, manner of recording evidence. Section 354, manner of recording evidence in inquiries and trials other than the summary trials under this code by or before a magistrate or session judge. The evidence of the witnesses shall be recorded in the following manners. Section 355, प्यारे व्यूअर्स, इसमें यह बताया गया कि रिकॉर्ड इन ट्रायल ऑफ सर्टेन केसेस बाय फर्स्ट एंड सेकंड क्लास मजिस्ट्रेट इन केसेस एंड ट्राइड अंडर चैप्टर नंबर 514, if not in the course of a trial, the magistrate shall make a memorandum of the substance of the evidence of such witnesses as the examination of the witnesses proceedings. Number two, if such memorandum shall be written and signed by the magistrate with his own hand and shall form part of the record. Number three, if the magistrate is prevented from making a memorandum as above required, he shall record the reasons of his inability to do so and open court and shall to do so and shall cases such memorandum to be made in writing from his detection in open court and shall sign the same and such memorandum shall form part of the record. Section 356, record in other cases. Number one, if trial before courts of session in inquiries under chapter 11 in the evidence of such witnesses shall be taken down in writing in the language of the court by the magistrate or sessions judge or in his presence and hearing and under his personal direction and superintendent superintendence uh, and shall be signed by the magistrate or session judge. Number two, evidence given in English. When the evidence of such witnesses given in English, the magistrate or session judges may take it down in that language with his own hand, and unless the accused is familiar with English or the language or the court is English, and authenticated translation of such evidence in the language of the court shall form part of the record. Number 2a. When the evidence of such witnesses is given in any other language not being English, then the language of the court, the magistrate or session judge may take it down in that language when with his own hand, or cause it to be taken down in that language in his presence and hearing, and under this personal direction and superintendence, and an authenticated translation of such evidence in the language of the courts or in English shall form part of the record. Number 3. Memorandum when evidence not taken down by the magistrate of judge himself. In case in which the evidence is not taken down in writing by the magistrate or sessions judge, he shall, as the examine of such witnesses proceeds, make a memorandum of the substance of what such witnesses deposes, and such memorandums shall be written and signed by the magistrate or sessions judges with his own hand, and shall form part of the record. Number 4. If the magistrate or sessions judge is prevented from making a memorandum as above required, he shall record the reasons of his inability to make it. Section 357. Language of record of evidence. The provincial government may direct that in any district or a part of a district or in proceedings before any court of session or before any magistrate or class of magistrate, the evidence of such witnesses shall, in the cases referred to in section 356, he be taken down by the session judge or magistrate with his own hand, and in his mother tango, unless he is prevented by any sufficient reason from taking down the evidence of any witnesses, in which case he shall record the reasons of inability to do so, and shall case the evidence to be taken down in writing from his detection in open court. Number 2, the evidence is so taken down shall be signed by the sessions judge or magistrate, and shall form part of record. Provided that the provincial government may direct the sessions judge and magistrate to take down the evidence in the uh, English language or in the language of court, although such language is not his mother tongue. Section 358. Option to magistrate in cases under section 355. In cases of the kind mentioned in section 355, the magistrate may, if he thinks fit, take down the evidence of any witnesses in the manner provided in section 356, or if within the local limits of the jurisdiction of such magistrate, the provincial government has made the order referred to in section 357 in the manner provided in the same section. Section 359. Mode of recording evidence under section 356 or section 357. Evidence taken under section 356 or 357 shall not ordinarily to taken down in the form of question and answer, but in the form of narrative. Number 2, the magistrate or session judge uh, may, in his discretion, take down or case to be taken cause to be taken down any particular question and answer. Section 360. Procedure in regard to such evidence when completed. Number 8. As the evidence of such witnesses taken under Section 356 or Section 357 is completed, it shall be read over to him in the presence of the accused, if in attendance or of his pleader, if he appears by pleader, and shall it, if necessary, be corrected. Number two, if the witness denies the correctness of any part of the evidence when the same is read over to him, the magistrate or session judge may instead correcting the evidence make a memorandum thereon of the objection made to it by the witnesses, and shall add such remarks as he thinks necessary. Number three, if the evidence is taken down in language different from that in which he has been given, and the witnesses does not understand the language of in which it is taken down, the evidence so taken down shall be interpreted to him in the language in which it was given, or in a language which he understands. Section 361. Interpretation of evidence. In interpretation of evidence to accuse or his pleader. Number 8. Whenever any evidence is given in a language not understood by the accused, and he is present in person, he shall be interpreted him in open court in a language understood by him. Number 2. If he appears by pleader, and the language evidence is given in a language other than the language of the court and not understood by the pleader, it shall be interpreted to such pleader in that language. Number 3. When documents are put in for the purpose of formal proof, it shall be in the discretion of the court to interpret as much thereof as appears necessary. Section 362 omitted by A O 1949. Section 363. Remarks respecting demeanor of witnesses. When a session judge or magistrate has recorded the evidence of witnesses, he demeanor of such witnesses well as under examination. Section 364. Examination of accused, how recorded. Number 1. Whenever the accused is examined by any magistrate or by any court other than a high court, the whole of such examination, including every question put to him and every answer given by him, shall be recorded in full in the language in which he is examined. or if that is not practicably in the language of the court or in English, and such record shall be shown or read to him, or if he does not understood the language in which it is written, shall be interpreted to him in a language which the understands, and shall be at liberty to explain or add to his answer. Such the whole is made conformable to what declares is the truth. The record shall be signed by the accused and the magistrate or judge of such court. Such magistrate or judge shall certify under his own hand that the examination was taken in his presence and hearing, and that the record contains a full and true account of the statements made by the accused. Number 3, in a case in which the examination of the accused is not recorded by the magistrate or judge himself, he shall be bound as the examination proceeds to make memorandum thereof in the language of the court or in English, if he is sufficiently acquainted with the latter language, and such memorandum shall be written and signed by the magistrate or judge with his own hand, and shall be annexed to the record. If the magistrate or judge is unable to make a memorandum as above required, he shall record the reason of such inability. Number 4. Nothing in this section shall be deemed to apply to the examination of an accused person under section 263. आज तक के लिए बस इतना ही। कल इंशाल्लाह एक नई वीडियो के साथ आपके पास हाजिर होऊंगा। कल तक के लिए मुझे इजाज़त दें। इजाज़त लेने से पहले मैं आपसे बहुत ज़रूरी बात करना चाहता हूँ। अगर मेरी वीडियो आपको पसंद आया तो लाइक और सब्सक्राइब कर लें मेरे चैनल को, और घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। अल्लाह आपका हम नासिर हो। अल्लाह हाफिज़।